Sorry, my hair is going to change a lot in this video because it is hot and I can't figure out a way to put it where I'm not sweating. A short while ago, I reviewed one of my 1L contracts cases and promised that if that video got 30 likes, we would do another video where I reviewed a different case from a different 1L class. Well, based on the existence of this video, I'm guessing you can figure out what results we got. Today we are going to be reviewing Summers v. Tice, a torts case that I studied during my first year of law school. But before we get into all of that, I owe you a welcome. So, welcome. My name is Nicole and I'm a second-year law student at Washington University School of Law in St. Louis, Missouri. If you haven't subscribed yet, please consider subscribing today if you enjoy weekly law school content, and like this video if you want more case reviews. I'll be real with you, torts is not an area of law I have a great grasp on. There's a couple different reasons for that, most of which are not relevant for this video, but thankfully for Summers v. Tice, there's only a few basics of torts law that you need to know to understand the case. First of all, what is a tort? A tort, in my understanding, is a civil wrong that causes some kind of injury to another person or their property. It's different than a criminal act where the state or government has decided that you have wronged society somehow. Although it's worth noting that some crimes can also be torts. For example, if you hit someone with your car, the state can criminally charge you, but that person can also sue you, and that suit would be a torts case. Summers v. Tice is a 1948 torts case wherein a plaintiff sued two defendants for a gunshot wound he suffered during a hunting accident. Just like last time, I've linked the case in the description below, so you should be able to pause the video and get that. You'll also see a link for a case brief, but I encourage you to wait until the end of the video to look at that. All right, let's see. I'm reading the case on my computer, in case that wasn't clear. Each of the two defendants appeals from a judgment against them in an action for personal injuries. So pretty much like every other case that you'll read in law school, this opinion is coming out of an appeal, where one party felt that the judgment from the original court was improper for one reason or another. In this case, the trial court had found in favor of the plaintiff and against the two defendants, so the defendants are appealing. Let's get into the facts of what happened to Mr. Summers. On November 20th, 1945, plaintiff and the two defendants were hunting quail on the open range. Each of the defendants was armed with a 12-gauge shotgun loaded with shells containing 7.5 size shot. Prior to going hunting, plaintiff discussed the hunting procedure with defendants, indicating that they were to exercise care when shooting and to keep in line. In the course of hunting, plaintiff proceeded up on a hill, thus placing the hunters at the points of a triangle. The view of the defendants with reference to the plaintiff was unobstructed and they knew his location. Defendant Tice flushed a quail which rose in flight to a 10-foot elevation and flew between plaintiff and defendants. Both defendants shot at the quail, shooting in the plaintiff's direction. At that time, defendants were 75 yards from plaintiff. One shot struck plaintiff in his eye and another in his upper lip. Alright, so Summers is on higher ground than the defendants. So when they both shoot at the same time at a bird that flies in between all of them, Summers gets shot twice in the face, I might add. And the court says, hey defendants, that was a dumb thing to do. You have to give Summers money now. The defendants appeal, saying on the second page, if you're following along, plaintiff was guilty of contributory negligence and assumed the risk as a matter of law, but the court barely gives that argument the time of day before dismissing it. The main and most important argument made by the defendants is that there isn't enough evidence to show which one of them actually caused the plaintiff's injuries. As the court admits, the one shot that entered the plaintiff's eye was the major factor in assessing damages, and that shot could not have come from the gun of both defendants. It was from one or the other only. The court cites a ton of case law that I encourage you to read if you're interested either now or later, but if you're following along, we're going to skip down to the middle of the third page to the paragraph marked 6. Can you tell we're practicing efficient case briefing? When we consider the relative position of the parties and the results that would flow if plaintiff was required to pin the injury on one of the defendants only, a requirement that the burden of proof on that subject be shifted to defendants becomes manifest. Hang on, we'll explain in a second. They are both wrongdoers, both negligent toward plaintiff. They brought about a situation where the negligence of one of them injured the plaintiff, Hence, it should rest with them each to absolve himself if he can. The injured party has been placed by defendants in the unfair position of pointing to which defendant caused the harm. If one can escape, the other may also, and the plaintiff is remediless. We're going to keep reading in just a second, but there's already a lot to unpack there. So the court says that both defendants did the bad act of shooting towards the plaintiff. It isn't fair for the plaintiff then to have to prove which one shot him in the eye, because if he's wrong or he can't figure it out, then he gets nothing. No one is held accountable. Additionally, the court says ordinarily defendants are in a far better position to offer evidence to determine which one caused the injury. One commenter on this case, Dean Wigmore, has summarized the conclusion of the case as follows. When two or more persons by their acts are possibly the sole cause of harm, or when two or more acts of the same person are possibly the sole cause, and the plaintiff has introduced evidence that the one of the two persons or the one of the same person's two acts is culpable, then the defendant has the burden of proving that the other person or the other person's act was the sole cause of harm. Essentially, each person who did the bad act and could have been the sole cause of the harm is responsible for being the sole cause of the harm until he proves otherwise. I really did my best to summarize this case and walk through it with you, but if you're still confused, now is the time to go back into the description and click that other link with the case brief. Compare what I said and you thought through during the course of this video with what the more professional case brief outlines. Think about the facts, the issue, the conclusion, the reasoning, and to see if you would have come up with the same answers that brief did. And if you have any more thoughts or questions on this case, leave them in the comments below. Let me know if you want more case reviews by liking this video, and subscribe if you want more law school content on this channel in general. Until next Saturday, God bless.